Welcome to Family Law Talk, presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a family law firm in the St. Louis metro area with offices in Missouri and Illinois. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. My name is Kirk Stange, and I am one of the managing partners of Stange Law Firm. Stange Law Firm is a family law firm with multiple offices in the St. Louis metro area. We have offices in Missouri, and we have offices in Illinois. Well, welcome to Family Law Talk with Stange Law Firm here today. Today we've got a very interesting topic, which is a question, in fact, that we get from a lot of clients and a lot of potential clients all the time. And the topic is this: is property and debt simply split 50-50 in a divorce? I think that's what a lot of people think. They think it's just an automatic 50-50, that the judge is just in kind of a butcher manner going to chop it down the middle and each party gets exactly half, and that there's not really a whole lot of thought process past that. And so that's the topic here today, and we wanted to spend some time talking about it since clients ask this question all the time. I should state before we get into the topic itself, as I always do, that the choice of a lawyer is an important decision that should not be based solely upon advertisements, and that the information you obtain today in this episode is general in nature, and it may not apply to specific factual or legal circumstance, and the laws additionally can vary in particular states. Therefore, if you require legal advice, you should definitely consult an attorney who is licensed and competent to practice law in your specific jurisdiction. All right, so let's get back to this topic again today, which again is a really common question we get from clients and potential clients, which is, and I think they just assume that in a divorce case, a judge is going to take the property and debt and they're just going to split it in half, and it's just simple, it's easy, there's not a lot of thought to it, and it's almost automatic. And so a lot of clients will take this whole concept and then take it a whole step further and say things like, do I really need an attorney? I mean, why do I need an attorney to help me out in my case? After all, the judge is just going to divide everything in half, right? And then in a lot of cases, maybe we're dealing with a client, and then you get into real issues about what the value of certain property is. So we might talk with a client about getting an appraisal done. Might be a situation when you're dealing with retirement accounts or investment assets where maybe we need a forensic accountant to help us out to present the best case forward. And a lot of times, again, clients are resistant to it because what they think is this is easy. I mean, it's basically a simple thing. It's almost kind of robotic, and that the judge just takes the assets. Husband gets half, wife gets half. That's kind of the end of the deal. Nothing past that matters. And again, they think it's very automatic. And so, again, that is the question. Is property and debt always divided 50-50 in a divorce? And here's the deal, which is if you look at the statutes in Missouri and you look at the statutes in Illinois on property division, and I have these right in front of me, and to the listeners out there, you can Google these and you can read about them afterwards, and you can read it yourself, which I think is a very helpful thing. But the truth is nowhere in the Missouri statute or nowhere in the Illinois statute is the word 50-50 in there at all. So it doesn't say 50-50. It doesn't state that the judge has to divide marital property and marital debt in a 50-50 manner. I mean, it's just not there. And I think that, surprising to a lot of people because they talk to family members, they talk to friends, and they just hear that 50-50 is it, and they almost assume this is just the law and that it's an automatic thing. So, I mean, the truth is this is a myth if you think property and debt in a divorce is just going to be automatically split 50-50. The statutes in Missouri and in Illinois don't say that. They don't contain those words. So to the listeners out there, I'm sure to a lot of you this is shocking, almost surprising, because a lot of folks just hear this all over the place. So let's talk about what is in the statute and what it specifically states. All right, the Missouri statute on dividing property and debt in a divorce is RSMO 452-330. Okay, and I'm just going to read it to you, and it states, in a proceeding for dissolution of the marriage or legal separation, or in a proceeding for disposition of property following dissolution of the marriage by a court which lacked personal jurisdiction over the absent spouse or lacked jurisdiction to dispose of the property, the court shall set apart each spouse, such spouse non-marital property, and shall divide the marital property and marital debts in such proportions as the court deems just, after considering all relevant factors. So key on the word just. What the Missouri statute says is just. The court has to divide the marital property and the marital debt in a way that is just, but nowhere in there does it state the word 50-50. It's just not in there. And then likewise, if you go to the Illinois statute on dividing marital property and debt, it's very, very similar, and it's contained in 750 ILCS 5/503D, and I'll just read the Illinois statute to the listeners out there as well. It says, in a proceeding for dissolution of marriage or declaration of invalidity of marriage, which means an annulment, or in a proceeding for disposition of property following dissolution of marriage by court which lacked personal jurisdiction over the absent spouse, or lack jurisdiction to dispose of the property, the court shall assign each spouse's non-marital property to that spouse. It shall also divide the marital property without regard to marital misconduct in just proportions, considering all relevant factors. So there you go. That term "just" creeps its head right back in there, just like in the Missouri statute. So again, just, and I just say to the listeners out there, what does "just" mean? Both these statutes talk about factors, and I will go through these here quickly today in the podcast. And again, I'd encourage the listeners, read the statute for yourself. You can Google it. We also have links to it off our webpage. If you go to the page called Family Law Tools and Statutes, we've got links to the Missouri and Illinois statutes on this point. But again, the term "just" is pretty gray. It's pretty ambiguous. And on a practical level, what Judge A might think is just, Judge B might have a totally different viewpoint on what's just. And what a judge in one particular county might think is just, a judge in a different county might look at the same case and have a different viewpoint on it. And so that's, I think that component of it's really key for the listeners out there. And, for listeners that follow judicial opinions, let me give you an analogy. If you look at the United States Supreme Court, they issue opinions on cases, and oftentimes the opinions are divided. In other words, a certain segment of the justices go one way and a certain segment of the justices go another way. And a lot of these cases are close, like 5-4 opinions. And so when you get into dividing marital property and marital debt in a divorce, and the legal standard is a term as vague as just, I just say to the listeners out there, this is not automatic. This is not black and white. Judges can do all kinds of different things, and different judges can look at the exact same case and really have a different take on it based on their view of what is just. So if you're looking for certainty in terms of how property and debt is going to be divided in divorce, the truth is I don't think you have much certainty going into proceeding. And what matters is the case that's presented in court, if your case doesn't settle, and the overall perception the judge has of you and your case in terms of the facts. And so very vague, this legal standard, not a whole lot of certainty. And quite frankly, the myth of the 50-50 division is just that, a myth. Now, I would just say practically, most judges kind of start with 50-50 in mind, and I think most judges would say that, but at the end of the day, it's not automatic. So a judge could find 55-45 just. They could find 60-40 just. And they could go many other different directions as well. And so, again, 50-50 is not in there. So let's look at the Missouri statute. The Missouri statute says the court is to divide marital property and marital debt in a manner that's just after considering all the relevant factors. Well, what are those relevant factors? And again, we'll go through these, and I'll try to kind of truncate a little bit because there's a lot of different factors there, but let's go through it here quickly. Factor one is the economic circumstances of each spouse at the time of the division of properties to become effective, including the desirability of awarding the family home or the right to live therein for reasonable periods to the spouse having custody of any children. Two, the contribution of each spouse to the acquisition of the marital property, including the contribution of a spouse as a homemaker. So, you can look at that and see the court can go kind of two different directions when you look at that factor. Three, the value of the non-marital property set apart to each spouse. So a spouse who's maybe wealthy coming into the marriage, and has a lot of different assets, a court can take that into account when they divide the property accrued during the marriage. And theoretically, they could, give the one spouse who has less assets coming in a greater share of the marital property, just given that the other party has their own separate assets that they brought in that they're going to get to retain. So that's definitely interesting. In Missouri, the court can look at the conduct of the parties during the marriage, and that is like shocking to a lot of the listeners out there, because a lot of listeners, they've heard that divorce is now no fault, and their assumption based on that no fault divorce is that conduct doesn't matter. Well, practically speaking, here's the deal. To get divorced back in the day, you had to prove specific things. You had to prove either like abandonment, some kind of physical abuse, an affair. There had to be egregious conduct in essence, and simply not being in love and growing apart and wanting to be divorced was not good enough back in the day. You had to have some kind of conduct to point to that showed the marriage was broken. But now, with no-fault divorces, if both parties want a divorce and they concede the marriage is irretrievably broken, then, in this day and age, judges are going to grant a divorce in the state of Missouri if both parties want it. But at the flip end, the court can look at the conduct of the parties in dividing the marital property and debt. So, an affair, physical abuse, verbal abuse, some sort of dissipation of assets, you name it. That can creep its ugly head right back into divorce. And so, if you think no-fault divorce means you can do anything you want and your actions and conduct doesn't matter, well, when it comes to dividing property and debt, conduct of the parties in the state of Missouri is a relevant factor. It's also a relevant factor, by the way, in terms of determining spousal support. So that's why a lot of divorces will delve into affair issues or abuse issues because it's a factor in dividing property and debt, and it can swing it. It could theoretically swing property division away from a 50-50 division to something different. And then the fifth factor in Missouri is the custodial arrangements for the children. So, based on how custody is going to work, the court can take that into account in dividing property and debt. So again, the court divides property and debt in a way that's just when considering these factors, and judges have a great deal of discretion in terms of what factors they ultimately rely on in dividing property and debt in the state of Missouri. All right, so that's the Missouri statute. Let's look at the Illinois statute. The Illinois statute is quite interesting, and it actually lists more factors in terms of dividing property and debt than the Missouri statute. And a key thing, too, by the way, is when you look at the Illinois statute, it has one key difference in that initial paragraph, which it says the court is to divide the marital property without regard to marital misconduct in just proportion. So Illinois attempts to take the conduct of the parties during the marriage out of the equation for dividing property and debt, but Missouri, it's still right in there in that statute. So kind of a big difference there between Missouri and Illinois. But let's look at the specific components of the statute. One is the contribution of each party to the acquisition, preservation, or an increase and decrease in the value of the marital or non-marital property, including any such decrease attributable to payment deemed to have been in advance from the party's marital estate, and the contribution of a spouse as a homemaker or to the family unit. So a little different than the Missouri statute, but similar. Two, the court can look at the dissipation by each party of the marital or non-marital property. So if somebody gambles, let's say, gambles away a bunch of money, this could be lots of different things. In some cases, it could be somebody maybe dissipates money on alcohol or drugs. But the short of it is, if you're irresponsible with money and you cause the value of the marital estate to decline, the court could deem that dissipation and take that into account. Three is the value of the property assigned to each spouse. Four, the court can look at the duration of the marriage. Five, the relevant economic circumstances of each spouse when the division of property is to become effective, including the desirability of awarding the family home or the right to live therein for reasonable periods, the spouse having custody of the children. Six is any obligations and rights arising from a prior marriage of either party. So if an individual is ordered to pay child support or maintenance to somebody else from a prior marriage, then that can come into effect. Seven, any antenuptial agreement of the parties. So if there's an antenuptial agreement, oftentimes called a prenuptial agreement or a postnuptial agreement, that can be taken into account in the division of property and debt under the Illinois statute. Eight, the age, health, station, occupation, amount, and sources of income, vocational skills, employability, estate, liabilities, and the needs of the parties. 9 is a custodial provision for any children. 10 is whether the apportionment is in lieu or in addition to maintenance. 11 is a reasonable opportunity of each spouse for future acquisition of capital assets and income. So in some cases, the court could look at it and say, listen, maybe in a particular case, husband or wife has a greater ability to generate income to replace assets lost than maybe the other spouse. And so under that factor, a court could definitely deviate from 50-50 custody and could give the spouse who has a lesser ability to generate income to get more of the assets, because it's not going to be easy for them theoretically to do that after the divorce. And then 12, the tax consequences of the property division upon the respective economic circumstances of the parties. So in terms of retirement accounts, for example, Roth IRAs versus traditional IRAs, those have terribly different tax consequences. And a court can take that into effect in terms of dividing the property and debt. But you see under the Illinois statute a lot of different factors. And again, let's take it back to the topic header here, which is property and debt simply split 50-50 in a divorce? And I know that's what a lot of people think. I know that's what a lot of people say. But the truth is, what both the Missouri and the Illinois statutes state is that marital property and debt is to be divided in a manner that's just when considering all these factors. And all the trial court has to do is make sure they give really the proper deference and the proper consideration to these statutory factors. But past that, they can do lots of different things. And while maybe a lot of judges will say they start at the presumption of 50-50, and while a lot of judges probably do that, they can deviate from it. And this is all the more reason you want to have an attorney helping you in your family law case. You want to have an attorney who knows how to put on a case involving the division of property and debt. And in some cases, it might entail, getting property appraised. It might entail having a forensic accountant to help determine what the value is, because these factors really allow the judges to go in a lot of different directions. So, again, this is the topic. Is property and debt simply split 50-50 in a divorce? And, again, the answer is no. That's a myth. It's an overly simplistic way of looking at it, and it's not what the statutes in Missouri and Illinois state. So, again, that's the topic here today. I want to thank the listeners for tuning in with Family Law Talk with Stange Law Firm. Definitely an interesting topic. I hope it was enlightening for the listeners out there, and we'll see you next time on our next episode. Thank you very much.
Thank you for listening to Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic, or to put Stange Law Firm to work for your family today.
Okay, round 2. Name something that's not boring.
A laundry? Ooh, a book club. Computer solitaire, huh?
Ah, sorry, we were looking for Chumba Casino. That's right. ChumbaCasino.com has over 100 casino-style games. Join today and play for free for your chance to redeem some serious prizes. ChumbaCasino.com. No purchase necessary. Void where prohibited by law. 18+ terms and conditions apply. See website for details.
When you wake up well-rested on a great mattress, everything becomes clear.
I do have a favorite child.
Things you missed when you were tired finally reveal themselves.
I use memes as a coping mechanism.
It's Mattress Firm's once-a-year sale and clearance. Get up to 60% off select Sealy, plus a free adjustable base, all with free and fast delivery. Deals this big won't last long, so don't miss out. The right mattress matters. We'll find yours. Restrictions apply. See store or website for details.